Very much for the invitation to come and speak. This paper doesn't address standard democratic deficit issues in the EU, nor does it address what Habermas refers to as the demos problem. My impression, however, there is a European demos or not. Rather, I address the issue of franchise rights and their intersection with institutional forms and levels of governance. So, in terms of theory, it's a type of theory like paper in a way, but that's fine. Unlike Germany, I don't get invited by the British government to participate in committees that are the good, being neither. I do, however, get regularly asked to Brussels to talk to them about problems of European citizenship. Particularly, I guess that's probably more invitations to come this year than it's the European citizen. And that's really what the background to this paper is. So this is a paper which is neither quite a policy brief paper, nor a more abstract philosophy paper. It's kind of between the two. Okay. So, in an article in the 8th of December 2011 issue of the French newspaper Libération, Philippe Cauer, a former French civil servant who's currently president of the Bureau of New Development, invited readers to join him in initiating a European Citizens Initiative, which proposes that the EU adopt a rule that all EU citizens living in another EU state after their nationality, so second country nationals or SCNs, be entitled to vote in the national elections of their state of residence. Cauer wrote, imagine being a law-abiding EU citizen living in the EU and having no right to vote for the government whose decisions will impact your daily life. Does that sound like an Orwellian nightmare? Think again. It's the fate of large numbers of your neighbours or friends. So the issue raised by Cauer is more than symbolically significant for the EU and its member states, even if the number of SCNs is currently estimated at perhaps only 12 million out of 500 million EU citizens. Not a negligible number. But it's more than symbolically significant, not least, because in highlighting this specific issue, it also draws attention to the more general field of demos problems, which emerges from the relationship of and division of powers between the EU and its member states, first. Second, the normative architecture of that relationship and the political incentives that it generates. And third, the mutual conditioning of EU citizenship and national citizenship. So in this paper, I'm not going to cover every possible demos problem, I'm just going to look at three main areas. Firstly, local municipal franchise rights. Secondly, national franchise rights. And thirdly, expatriate voting rights of EU citizens living outside the EU. Addressing these issues will also draw attention to a further background issue that intersects with them, namely the relationship of the question who counts and where in the EU to the weighting of representation, the number of seats allocated to each member state in both the European Parliament and of voting rights in the Council of Ministers. Currently these weightings are organised in a way that's related to resident population sizes. Okay, not in a directly proportional manner, and there's actually a very interesting and lively debate about what will constitute a fair rule for the allocation of EU Council votes. But I'll leave that aside. But there's a kind of prior normative question raised by this background issue. Why are population sizes the relevant consideration? Consider that the distribution of seats in national and local elections is not typically a function of population sizes of constituencies. It's typically a function of the number of eligible voters. And there's a basic reason for this, namely that it's the demos and not the populos that is the normatively relevant item for electoral purposes. Although one should, of course, mention America here, where they do have organised congressional seats on a population basis. I think historically, because it made gerrymandering much easier. So I wouldn't recommend it. The Liberal Democrat MEP Andrew Duck has argued in favour of the use of population sizes on the basis that, quote, the Madisonian approach suggests that the European Parliament represents not only de jure EU citizens, but also represents and has a duty of care towards anyone else who abides in the territory of the Union, including minors and delegates. This being the case, the traditional method of distributing seats in the Parliament on the basis of total resident population, to say nothing of counting votes in the Council, is the right one and should not be amended. But this claim is highly contentious. The fact that a representative's duties of representation extend beyond those who can vote for and against them in no way implies that persons other than voters should count in determining constituency sizes and seat distributions. Although it may well be an argument, and indeed is, I think, for differential resources for the offices of representatives. So, for example, a representative whose constituency contains a large voting eligible population can reasonably be given greater resources for his representative activities than one whose constituency is not so characterised. So imagine two towns, Procreatia and Condominia, each with 60,000 eligible voters, but where households in Procreatia have an average of 2 adults and 4 children, whereas in Condominia the average is 2 adults and 1 child. Now there are clearly grounds for suggesting that Procreatia requires more schools, playgrounds and other resources than Condominia. But does this provide any democratic grounds that don't appeal to enfranchising children for arguing that Procreatia should have more MPs than Condominia? I'll return to this issue in relationship to the distinct incentives in the interaction of EU membership and member state membership that population-based and demos-based criteria generate in respect to the 3 cases of voting rights that are the focus of this paper. But we can notice that each can generate problems of under or over inclusion. In the case of a population-based criterion, this emerges clearly in the relation to third country nationals, since the criterion will count resident third country nationals independent of their access to membership of the demos, and hence provides no incentive for member states to incorporate third country nationals. In the case of a demos-based system, the problem is that it provides member states with incentives to expand the demos in ways that extend beyond what may be normatively desirable. For example, by adopting an unlimited use sanguinis rule, or by enfranchising expatriates. So, what I'm going to do is just do a very brief little bit of theory and then look at the 3 cases. So citizenship is most basically membership in a self-governing polity, where citizenship has a necessary relation to voting rights as the expression of such membership, in the sense that the citizens must be entitled to vote under rules that can be justified to all subject to them. For our current purposes, I want to note 2 points. First, legitimate political authority is characterised by the right to rule. That is the right to impose duties on subjects of rule, to conduct themselves and their relations to one another in accordance with the norms established by the political authority, insofar as these norms are compatible with basic demands of justice. Second, legitimate democratic rule is a form of rule in which, in some suitable sense, the governed govern. It's a form of reflexive authority, in which we impose duties on ourselves to act in accordance with the norms and rules that we have determined. Now, construed thus, we have a prima facie criterion for inclusion within a political community. Namely, if you're subject to political authority, then you should be included within the demos of that policy. This criterion is, however, problematic in that it doesn't address the question of who is legitimately entitled to be a subject of a political authority. So two examples illustrate the problem. First, an irregular migrant may be subject to the rule of the polity in which they reside, in the sense that he or she will be held accountable to the rules established by the political authority if found in breach of them. But prima facie, he or she is not legitimately entitled to inclusion as a subject of rule, because he or she did not acquire legitimately the status of being a subject of rule. Hence, presumptively, an irregular migrant who commits a crime may be punished for that crime and then subject to the penalty of, say, deportation that pertains to their non-lawful presence. Second example, expatriate citizens are subjects of rule of their state of nationality, since they have a duty to comply with the rules of the relevant political authority whenever the conditions of application of these rules are satisfied. And this problematically entails that for a polity with perpetual disambiguous transmission of citizenship, an next generation expatriate will be entitled to franchise. So what's needed is some criterion for establishing the legitimate acquisition or loss of the status of being a subject of rule. And to address this value, we need to consider the value of political membership as a free and equal consociate in a self-governing community. Well, I think we can distinguish two very general sets of reasons for valuing political membership. First, protective or enabling reasons, which stress the instrumental value of political membership in terms of protecting or enabling the conditions of social and political autonomy. Second, expressive reasons, which emphasize the non-instrumental value of standing in a relationship of political community with others, of political membership as a source and site of political belonging. And these two general sets of reasons provide two very general criteria for acquisition and loss of political membership. So one, an entitlement to a fair opportunity to acquire political membership, insofar as one is dependent on the relevant political authority for the protection or enablement of the basic conditions of one's social and political autonomy. And two, an entitlement to a fair opportunity not to suffer the loss of political membership, insofar as the political community is a source or site of non-instrumental value for oneself. Now, the first of these general criteria provides a basis for addressing the distinction between refugees, regular and irregular migrants, since what constitutes a fair opportunity of acquisition can vary according to the different needs and circumstances of dependency. Thus, for example, it's prima facie reasonable that refugees have an accelerated path to the acquisition of political membership relative to regular migrants, and that irregular migrants have a slower path to the acquisition of membership than regular migrants, although these judgments are feasible and may be contextually variable. The second criterion provides a basis for distinguishing different generations and categories of expatriates in terms of variable criteria of fair opportunity not to suffer loss. Thus, for example, the criteria for first-generation immigrants will be much weaker, say, for simple declaration, than for second-generation immigrants, who may, for example, be required to spend a period of time in the state of nationality or otherwise demonstrate a commitment to it in order to retain political membership. Such criteria will presumptively be more demanding for third generation and may reasonably be taken to converge with criteria for non-citizen residents to acquire political membership, say 5 years residence, which is the EU average. Now, what I want to do is just take those very general rules, and I'm aware that I'm just being very sketchy here, and deploy them in relationship to the issues of franchise rights in the European Union. So let's start off with local government, municipal voting rights, second country nationals and third country nationals. So municipal governments can be modelled as primarily concerned with providing services for residents that pertain to their status as residents. On this basis, one can argue for jus domicilii as an adequate and comprehensive criterion of local political membership, roughly government of residents, by residents, for residents. The normative considerations sketched out above support this stance in terms of protective enabling reasons for political membership. This is not to deny that political membership in one's municipality can also be a source of non-instrumental value. It's simply to say that ceasing to be resident in the municipality is, given the specific kind of practice that municipal government is, a sufficient reason for loss of membership. If we bring this normative criterion in relation to the European Union, we can note several respects in which it stands in a somewhat mixed relationship to the norm of jus domicilii at the municipal level. In that while the EU has adopted a rule of municipal franchise for EU citizens, whichever member state they reside in, the rationale for this norm in the design of the Treaty of Maastricht appears to be that, given the constituent commitment of the EU to freedom of movement of EU citizens, such citizens should not be politically disadvantaged by acting according to this norm, rather than an acknowledgement of the distinctive character of municipal rule. This situation sets up a puzzle, since it's unclear, and even more so post-Lisbon, why the same logic would not apply to national voting rights. Indeed, as I'll argue shortly, this logic has actually rather more application to national voting rights. However, despite this rationale, the EU rule may be seen as introducing a positive normative dynamic into this arena in at least two respects. First, in requiring the transformation of municipal voting rights to a restrictive transnational rule, the EU broke the hold of a strictly nationalist rule in those member states which were so characterised, and opened up the arena of local citizenship and voting rights to political argument. The mere fact that the EU rule serves to highlight the salience of residents may provide support for a more universal rule. Secondly, following on, with a number of EU states, Belgium, Denmark, Finland, Ireland, Luxembourg, Netherlands, Sweden, Estonia, Hungary, Lithuania, Slovak Republic, Slovenia, have, with various minor qualifications, followed out this logic and adopted a straight jus domicilii, i.e. any resident, regardless of whether they're EU citizen or not, is entitled to local voting rights. And more generally, the EU has sought to promote third country national incorporation at the municipal level and the harmonisation of member state rules. It's particularly ironic in this respect that it's adopted a rule for distributing European Parliament seats and European Council voting rates that, because based on resident population rather than demos, provides no structural incentive for states to look to incorporate third country nationals into the political membership of the state. So if you think about, think about the very large Turkish population in Germany, okay? They only count for the number of seats that Germany gets in the European Parliament and the voting weight of Germany in the European Council. And they count whether or not they're given German citizenship. So there's no actual incentive set up by the EU institutional dynamics for the incorporation of those third country nationals. Okay, so let's move to national voting rights and second country nationals. In the case of independent states, external voting rights may be required or permissible depending on those to whom they apply. Fair opportunities for voting are required for transient absentees, short-term temporary workers, students, etc. And also for those whose externality is a function of state roles, diplomats, members of the armed services. On the same grounds that they're ruled out for those who are merely transiently present, tourists, students, short-term temporary workers, namely subjection to the political authority of the state. In the case of long-term expatriates who are not performing state roles, voting rights are permissible for national and legislative and presidential elections, and only required in the case of constitutional referenda. They're permissible in the former case because inclusion in the demos is neither forbidden nor required, as it were, on the basis of subjection to political authority of the state. Residence is not a necessary condition of subjection to collectively binding decisions or having a stake in the future of the party. But nor are residents are not subject to the comprehensive application of rules that characterise its residence. So, in the case of constitutional referendum, however, they are required because these concern the character of one's legal personality as a citizen and more generally the terms of the political association of which one's a member. So, there was a famous argument by, or famous in this context of people who know about this stuff, by Claudio Lopez Guerra in Journal of Political Philosophy, which basically said expatriate citizens should not have any voting rights. And they shouldn't have any voting rights because only those who are subject to the collectively binding decisions of the polity, okay, which is a residential, a territorial entity, should have voting rights. So, you know, they must be excluded, was the argument. Now, this was a truly spectacularly awful argument, and I was always astonished that the referees didn't pick this up, because what motivated his thought was the Mexican referendum on whether to allow Mexicans living abroad to have expatriate voting rights. Okay? So then just ask yourself the question, who is collectively bound by the results of the Mexican referendum? And the answer is all Mexicans wherever they live. Yeah. So, for example, if the UK decided to hold a referendum on withdrawal from the European Union, all citizens, all UK citizens, no matter where they reside, would be bound by this decision. And if this were their only member state nationality, their entitlement to EU citizenship would hang on the outcome. Now, it might be objected that this bias is the case because it affects significantly non-resident citizens, so consider an alternative, but the point's still the same. Irish 2004 referendum on constraining use solely, which by definition did not affect any external citizens, since their children born abroad would still claim Irish citizenship through jus sanguinis. In this case, it might be argued that since the outcome of the referendum would apply to external citizens only in the same way that domestic legislation applies to them, i.e. when they come home, that voting in constitutional referenda should be treated like voting in national elections, namely as permissible, not required. I would resist this conclusion, since what differentiates the constitutional case from standard domestic legislation is that it concerns the basic terms of the political association. If citizenship is fundamentally membership in a self-governing political community, and constitutional rules express the basic commitments of that political community, its juridical understanding of its own self-governing character, then all citizens should be entitled to a say in relation to those rules, irrespective of whether they are individually affected by any important interests. But how do such considerations change when we move from considerations of states to consideration of the EU and its member states? That the normative implications of political membership are changed by the shift in institutional context is most obviously demonstrated by the fact that given the institutional design of the EU, it's not compatible with civic equality of EU citizens to have voting rights in national EU elections in more than one member state. Whereas in the case of distinct states, there is no breach in civic equality of a person exercising voting rights in distinct and unrelated electoral contexts. But it's important to note that the significance of the transformation depends on the type of governmental entity that the EU is. A point that we can explore by way of contrast of the EU with purely intergovernmental and fully federalised systems that are also committed to free movement within the territorial area they cover. In the case of a purely intergovernmental structure, the norm of free movement is grounded on a joint commitment to a shared aim or purpose, such as, for example, the European market. In terms of national citizenship of the states involved in this intergovernmental project, the normative context remains largely equivalent to that of independent states, but not wholly, since the shared purpose brings into play the principle of justice that the partners to this project should not act to frustrate this joint enterprise, and should, where compatible with their distinct national contexts and projects, aim to facilitate it. Such a principle could be expressed, for example, by offering preferential treatment to the citizens of partner states for access to membership rights and for dual citizenship. In the contrasting case of a fully federalised system, the norm of free movement may serve instrumental purposes, but is fundamentally a norm of social justice, expressing a basic liberty of citizens as federal citizens. And as such, state citizenship is subordinate to federal citizenship, in the sense that freedom of movement requires that anyone exercising their right to cross state borders must not be disadvantaged at any level of citizenship within the federal structure. An obvious way to institute such a rule of justice is to adopt a residence-based rule for citizenship in the states that comprise the federal union. It's not the only way to institute such a rule, but given the territorial mode of governance, it has the advantage of aligning voting rights with primary contexts of governance. Now, the EU stands between these examples in an interesting way, since its commitment to freedom of movement has moved from an economic model, largely tied to an intergovernmental structure, to a more civic model, which retains some intergovernmental features, but is developing some federal ones. While it's the case that this civic model now identifies freedom of movement as a right of citizens as EU citizens, it remains the case that the EU is a mixed type of governmental entity, and consequently the relationship between EU citizenship and member state citizenship cannot be conceptualised simply in terms of the priority of the former or the latter, but is rather to be seen as engaging a form of mediation between the two. Now, the problem that we have here is that European Union citizens may find themselves with any of the following results if they move to another country. They may have no votes, 1 vote, or 2 votes. Okay. And while there are actually rules against exercising 2 votes, albeit rules that aren't actually implemented very stringently, there is no rule requiring 1 vote. But, given that freedom of movement is now a civic right, it is incompatible with the legitimate exercise of a civic right that one, as it were, becomes politically disenfranchised as a result of that legitimate exercise. Okay? So the EU is now in this curious position whereby people can be politically disenfranchised through the exercise of what is a basic civic right. Okay? And whether they are or not is just arbitrary. It depends on local domestic legislation of particular states they're moving from and to. So, if it's the case that the EU should ensure the enfranchisement, as our arguments of second country nationals, the next question is where? So here are 4 different simple rules that you could adopt. 1, national voting rights in state of residence. National voting rights in state of nationality. The choice between 1 and 2. Or a time-differentiated combination of 1 and 2, which starts with national voting rights in state of nationality, and after a period of residence switches to national voting rights in the state of residence. Okay. Now, number one, national voting rights in the state of residence is the characteristic feature of fully federal systems, and has the advantage in such structures of ensuring that voting rights track the primary context of governance. The normative issue raised by one is whether the political autonomy of citizens resident within a member state is adequately secured if they lack national voting rights in that member state. This is a serious issue, but it should be noted that one also has the disadvantage of effectively severing the formal democratic relationship between second country nationals and their member state of nationality. By contrast, 2, national voting rights in the state of nationality, maintains that relationship, but means that EU citizens cannot vote in what arguably remains their primary context of rule, state. Acknowledging these combination of advantages and disadvantages may incline us to 3, maybe letting people just choose which one they want to vote in. Okay? While 4 may be seen as the attempt to combine the advantages and minimise the disadvantages of 1 and 2 in a way that registers that the salient centre of gravity of one's political life changes over time. Now, in response to 1, it may reasonably be argued that insofar as an EU citizen enjoys local and EU political rights, as well as rights to join and found political parties and organisations in the state of residence, and other general rights of political participation in democratic political life of the state of residence, the conditions of their political autonomy are sufficiently secured. This is, I think, plausible if and only if such EU citizens also enjoy a right to acquire political membership of the state of residence within a reasonable time frame. In the absence of such an entitlement, they're forced to trade off the good of membership in the primary context of governance against the good of free movement. The right of membership need not be presented on the same terms available to resident non-EU citizens. For example, one could argue that the incorporation of resident EU citizens should take a different form to that of non-EU citizens. But I want to leave that aside here. Rather, I just want to note that the objection to 1 entails that 2, when appropriately linked to rights of naturalisation, effectively accommodates 3 and 4. So we can call this 2+. 2+ basically says that all competent adults shall have a fair opportunity of acquiring political membership or nationality in the member state of residence, and all emigrant nationals of a member state who are resident in the EU and do not have political membership in their member state of residence shall be eligible to vote in the national elections of their member state of nationality. So that rule, that more complex rule, covers, I think, gets the best out of all the others. Does this mean that we should be able to insist that member states will institute such a rule? No. That's just the minimum form such a rule should take. Member states may choose to incorporate more maximal rules than that. So, sorry, I realised I just looked at the clock and then I started, so I should speed up and or try and conclude. But this question leaves us with a further problem. Even if, as it were, kind of democratic justice supports the introduction of such a rule or some more maximal form of it in member states, how should that process take place? So, for example, one way in which it can take place is through the European Court of Justice issuing a series of rulings on European citizenship. Okay? And the Court of Justice has shown in recent cases a willingness to, as it were, rule on national citizenship issues. Okay? So the case of Rockman, for example, was a case in which someone would have lost their EU citizenship if the state, in this case Germany, had been allowed to strip them of German nationality. And the European Court of Justice said, no, you can't do it. They wouldn't have become stateless, they would have just lost their European citizenship. And the European Court of Justice said no. So the Court of Justice has shown a willingness in recent time to engage in the area of member state citizenship rules, start engaging in that. However, it is also the case that in the relevant EU treaties, member states reserve the power to determine their own membership laws, their own nationality laws. Those powers were explicitly removed, explicitly exempted from EU competence. So they were retained by member states. So the political question that arises here, the further question that arises is, who should be able to determine what the rules are and what is the process by which that determination should take place? And my own view is that that has to be a political process of negotiation with member states and not a judgment by the, or a set of judgments by the European Court of Justice. Because the only way in which, as it were, it can be politically legitimate in reconfiguring the normative institutional makeup of the EU is through some kind of treaty process. The final point that I'll make is just to say, since I didn't get on to the last Demos problems, is to say what I think the kind of, or I hope the paper illustrates, is that sometimes at least it is worth political theorists, as it were, attending to the kind of detailed institutional structures of politics in order to kind of discern what the problems and also prospects for fair rules of democratic inclusion are. Thank you.